All right, well, I guess we're going to get started. It is 3:31, and we'll just boo anybody that walks in late. I'm kidding. All right, so this is as much your talk as it is mine. So I'm here to cover what you want to cover. I have prepared slides for privacy. If you don't understand what I'm saying, please do let me know. If I'm going too fast, which I'm known to do also let me know. And I will make time for questions at the end. So yeah, just let me know if it's too basic or I need to slow things down a little bit. So, my name is Rian Kinney. I am a tech and privacy attorney. I work with online businesses for all of their legal needs. Primarily, recently, I've been doing a lot of privacy work. I just pitched, I'm dealing with companies that even have in-house attorneys on staff that don't know privacy law or are familiar with it because it's rapidly emerging, and you can't be an expert at everything, and neither can they. So they'd rather outsource it. Designations here, if you're not familiar, IAPP is International Association of Privacy Professionals. They have great resources that you can look for free. Also, the designations are CIP-PE and CIP-M. It's Certified Information Privacy Management. That's the training and the test to be able to create privacy frameworks for corporations, which today I actually structured my talk as kind of going through a privacy framework for your organization. So we'll go through what that process looks like. And the CIPPE is Privacy Professional for Europe. I took Europe first because that had GDPR last year, and US probably will get federal legislation soon, and I'd rather take the test after the law changes because, hey, I want to know what's going on. So, before we get into your organization and privacy framework, it's good to understand a little bit about privacy law as a whole. So, we're going to talk about both European and American law. US law is very different because data belongs, at least has belonged to the owner, to Google, to the collector, whether it's an app or a website. It doesn't belong to the individual, and they can pretty much do whatever they want with it, and they have. We have the opt-out culture rather than opt-in, which differs from GDPR. We are a lot more litigious in this country, where Europe functions as more of an administrative process, and people fear government here and trust businesses, where in Europe it is quite the reverse. I don't want you to know all of these laws. You don't need to. The reason that I've included them for you, again, I will make my slides available on Monday on my website. Feel free to take a screenshot. But when you're working with clients, the US has a very fragmented approach to privacy. So the GDPR, the General Data Protection Regulation that was enacted in Europe, is a universal law and regulation that covers the European Economic Area, which is the 28 EU countries and 3 additional, Norway, Liechtenstein, and Denmark, I believe. But here in the US, it very much depends on the type of information that you're collecting. So it varies by whether it's the age of the user, whether it's the type of information, and privacy law has existed in the US for decades. This is a newly emerging area of law because the GDPR and the European Union enacted it, and they actually gave it teeth in the enforcement arm. But we've had these laws forever. We just, again, have this very fragmented approach. And as fragmented as the actual laws are, so is our enforcement. So we have FCC and FTC are the major regulators on a federal level that enforce these. But not a lot of enforcement goes out. Like, the percentage of enforcement has been drastically low, and the fines have, it's kind of the wild, wild west is how people refer to privacy in the US. Did you guys have any questions about these laws? Not that, again, we're not covering these laws, but did you have any questions about what's up here or why it's there? Sure.
What's the
CCPA, thank you for, yeah. So CCPA is the Children's Online Privacy Protection Act. That's regulated by the FTC, and that is something that all of your privacy policies should address, whether it's your privacy policy or one of your clients or users. If your marketing or your website markets to children under 13 or 13 and under, you're collecting information. And again, this applies to websites and apps. So if you're selling like Candy Crush and you're collecting children's information, you need to go to the FTC website and review the guidelines for CCPA and integrate that into your privacy policy. If you're not, just make a statement in your privacy policy that says we do not actively advertise, target, or collect information from children 13 and under. Yes?
Are those all at the federal level?
Yes. Well, so yeah, I did differentiate them. Yeah, these are all federal. Yep. But we're moving on. Yes, sir? Oh, wait. Okay. So regional requirements. California leads the wave. Why am I talking about California, Ryan? We're in Florida. Well, it's the 5th largest global economy, and California always leads the way when it comes to privacy and really tech law. We have Silicon Valley there. So CalOPA, enacted in 2003, was the first privacy policy legislation in the US. And many states have either adopted it as written or used it as a basis and draft for their laws. So any of these laws that are listed here are going to be the most stringent laws in the US regarding privacy right now. And we're going to talk about adopting a jurisdiction agnostic approach. And that basically means when you comply with the most stringent laws, you're automatically compliant with the less stringent laws. So if you're going to be making changes to your website, your business practices, don't you want to be ahead of the curve? And also, these California laws, much like the GDPR, are extraterritorial, meaning you don't have to be a business located in California for them to affect you. You only need to be collecting information about California citizens. So unless you are intentionally limiting where you collect money, funds, who you're advertising to, block California as a state, you need to comply with these laws. So the CCPA is something, who's heard of the CCPA? Yay, okay, so we're all gonna learn that you don't need to know much about the CCPA. So, how many of you have heard of GDPR? I didn't ask that to begin with. Thank you. Okay, so almost everyone in this room has heard of GDPR. So CCPA is what they're touting as the US's response to GDPR. It was California legislation that was pushed through, ratified unanimously, and should be coming into effect in 2019. The reason I say you don't necessarily need to know about, oh, the slides are out of order, I see. So the reason that I say that you don't necessarily need to know about the CCPA is because it only affects businesses who have annual gross revenues of 25 million or more. It receives sales shares of information of 50,000 or more consumers, derives 50% of its annual from selling consumer personal information. If that's not you, it doesn't apply. It doesn't mean that you don't still want to look to that law to see what's happening, because again, we're talking about ascribing to the most stringent law in the land. But the other reasons that the CCPA isn't a huge concern of mine is because since it's been enacted, it's gone through several major revisions, while simultaneously the U.S. is pushing forward federal law. There's, I think, 3 privacy draft bills that have been circulating. I don't know if any of you saw that Congress actually asked for the tech industry to submit comments for how they would like privacy approached when it's actually legislated. But that is a lot of the reason that the Zuckerberg, that they're looking into and investigating what has happened so they can draft legislation for what should happen. So again, contrasting with European law, it's pretty much flip-flopped. So in Europe, they have a strong sense that privacy belongs to the data subject. It's your right. You own your information and information about you, and you get to control who it's shared with, how it's shared, whether people maintain it, and it's an opt-in culture. So the presumption is they need your permission and consent for anything. And the people there trust governments and fear businesses. Did you have a question?
Yeah, so the privacy belongs to owners, that apply to video and pictures and public spaces as well?
I'm sorry, what was your question?
So like, say you post a video on your site, like the subject of that video.
Yes, so for Europeans, it gets even more stringent. Europeans have a right to their image even in events. So if I were to come to a Joomla space and I didn't want my photo taken, they should have separate areas set up where I can stand and not be photographed. Just because I attend an event doesn't give you the implicit ability to take my photo. I'm sorry, go ahead.
Sorry, I didn't mean to.
No, go ahead.
Even in public spaces where
Yes.
I guess you would have no expectation of privacy.
They are allowed, you have the ability to issue a takedown. And I don't know the specifics of all of European law. I know, GDPR and things like that, but I specific cases as they come up just kind of mystify me. It's like, really? I attend an event and you have to set up a space where I can't be photographed? Because here in the US, I'm sure you guys all signed a waiver or some kind of acknowledgement when you purchased your ticket to come here? Really?
Here, I think it's just like.
You didn't have a web page to click? Okay.
No, there was a web page. We didn't sign like a waiver that's, for.
No.
marketing purposes.
Yes, again, in the U.S., it's not that expectation. I'm sorry, I'm standing like in front of the camera. You can see. In the U.S., it's not that same expectation of price, so it's not going to be a crazy waiver. In the U.S., it's going to say something to the effect of, I consent to my photo or video being taken, and if you have a problem with it,
If that, yeah.
you opt out. Again, that difference between opt-in and opt-out. Sarah, go ahead.
So like, if you put it in perspective, there's some children or some people that are under like child protection where they're sent to another family and they actually have a comment in a school setting or at an event that they cannot be photographed because they're recognized because they're in child protection.
Right.
And then-
Children's rights, even in the U.S., have a lot more protections.
And then there's also that if you do something like I did 3 Day for the Cure with Susan G. Komen, and also with American Diabetes Association, is that there is a waiver that does cover that particular thing about you may be photoed and you have to sign that waiver. If it's not there,
So
then it's going to be on there. It applies.
So as of for what it's worth, if any of you are involved in organizing events, typically your venue insurance will require these waivers. So you do sign a waiver, you just might not have read it. It's a checkbox on that form. I read them all because I'm a nerd and I want to know what did they actually cover here and what did they leave out. While we're on the topic, I just want to give you guys as much information as possible. I recently drafted a children's waiver for another tech event, and in the state of Florida, there's statutorily required language for minors, parents being able to assume the risk for minors. So that's something to know because not a lot of organizations know that there is, verbatim, you have to cut and paste the statutorily required language in the state of Florida for the children's waiver to be enforceable. So much like I told you that the U.S. has had privacy legislation around for decades, which may come as a shock to some of us because it's the first time we're ever hearing of it. GDPR isn't a revolution, it's an evolution because these are the guiding principles that have evolved over time. So what is now the GDPR is a regulation. Before that, it was an initiative and it served as guidelines. Now it's actually law with an enforcement mechanism. But Europe has been functioning this way for a very, very long time. So I'm not trying to scare you, but I do want you to understand why we're talking about the GDPR. These are the numbers since GDPR became enforceable in May 25th of 2018. And it's, these numbers are from the European Commission. Hey, I cited a source. It's not a fake fact. But there have been over 41,000 breaches. I forget what this is right now. I'm so sorry. Was it breach notifications? Oh, complaints. I'm so sorry. Complaints. There have been over 95,000 complaints in the past 8 months. And what makes EU so interesting as far as the enforcement mechanism is, again, in the US we tend to sue, and it's who has the money, the attorney, the whatever to sue you. Here it's an administrative process, and it's not something where the regulatory body has to take the action. Anyone can file a complaint against you for failing to adhere to these laws. So it's a lot more policed, and it's a lot more to be concerned about. So we've already kind of defined jurisdiction agnostic approach. The GDPR is the most comprehensive privacy law that exists today. So it covers all of the various aspects of a privacy framework that you would want to integrate. And don't be afraid, we're getting to a really fantastic part. So these are the laws that were integrated into, or the rules that were integrated into GDPR. You have to have a very clear and concise privacy policy. What's funny and interesting about that is the fact that you now have to have a clear and concise privacy policy, while at the same time they have the most comprehensive, confusing and complex privacy rules existing. So how do you really boil that down? But we're figuring it out. The thing is, everyone is complaining that no one knows what the GDPR really requires, because they have kind of broad principles, but they don't actually spell out what the specific requirements are. But it's called the General Data Protection Regulation for a reason. It's meant to be general because, again, there's 31 countries that are adhering to this. So first, they have the overarching, what we would consider federal law, and then the individual member states are able to kind of modify some of those laws and make it more specific to their country. So it's kind of trial by error. We need to be taking steps when we're building websites and for our own businesses to align with the principles and let the lawsuits for Google kind of guide us of this is okay and that's not okay. And that's why you need to be aware of this, because again, it's an evolving area of legislation. You've all heard of GDPR. Do I need to go through this slide, or are you guys pretty comfortable with this information? Are you familiar with the privacy principles with the GDPR? Anyone say no, like I really need you to tell me? Okay.
Basically.
Yeah. So, and breaks it down in basic language, but you guys understand that, so we'll skip it. So privacy tools aren't legal compliance. I'm sure you guys already know that. Similarly, with accessibility, an automated tool or a scan isn't going to get you to comply. Somebody that is preaching that they have a compliance plugin for GDPR, run as fast as you can. There is no possible way that they can make your site compliant because it's a comprehensive body of law that, again, requires a privacy policy and different mechanisms of how your website functions. So a plugin can't do all of that. So we're going to talk about the privacy framework and how you would kind of organize this for your business. And I say start with yourself before you work with clients, because you're going to figure out a lot about the process while you're doing it. So here's the great news, guys. You guys are functioning and working in a platform that has committed to privacy. And you're going to want to first look at the tools that you're using and the third-party integrations. Check data everywhere. And we're going to go back to this slide, but Joomla 3.9, are you guys familiar with the privacy suite? Who is? Who isn't? Yes?
It exists.
Okay, guys. I'm here for a breakdown. Ready? Okay, so everything that we talked about with the GDPR, they require that you provide website and app users with the ability to access their information, to modify or change their information, to delete, to collect consent. I didn't go through the whole consent for sensitive information versus personal information. If you have questions about that at the end, we can definitely go through it. But 3.9 has integrated these into Joomla, and they actually have a dashboard on the back end that makes compliance with GDPR very easy for you. So they actually have privacy tools that allow for the export and erasure of client information, where other platforms are still trying to get to that level. They actually have to continue to build within the framework and code this where you guys have it as part of your platform. The thing I am most excited about as an attorney, and yes, you can see my nerd shining through, is the consent management, because it is an absolute nightmare to, okay. So again, with the type of information that you collect from your users, whether it's sensitive data or personal data, you have to get consent and verified consent. And you have to be able to prove to a data protection authority when the consent was collected, whether it's still valid, or when it was revoked and how it was revoked. There's also rules that you have to, the revocation of consent has to be as easy as it was to assent, but this is, and it's built into Joomla. So, and they actually document the consent management. They track when it was collected and when it was revoked. And they have the documentation there for you, because that's the other part of this process that everyone else is trying to deal with, is the actual documentation. God forbid you get a question or investigated. Companies aren't documenting consent management right now. Access and erasure tools. Again, this is all in the dashboard. You can go in and look at the users of your website and allow them the ability to change their information. You collect my email address and my address changes. In the EU, I have a right to request that my information be changed. Now, if you're a small business, do you want to have to go in there and manually find where in the log it is to make that change? No. You want your users to be able to do it and document it for you. Again, yay, Joomla. And the plugin data disclosure. Another aspect of the GDPR is the fact that the site owner is legally responsible for compliance of all aspects of their website. That includes third-party vendors and plugins. So using bad plugins is dangerous. Joomla has created the core API where you can go in and it will, for plugin designers, it will actually disclose to the users what the data collection and privacy functions are, which makes it easier to generate privacy policies for people like me when the plugins come with documentation that says, hey, this is the information we collect, this is where it is, where it's stored, how it's stored. It does all of that with this function. And lastly, and most importantly for you all, if you haven't checked it out, is the Joomla extensions directory. They've actually broken it out for data privacy extensions. So if you're looking for cookie consent, which we can talk about that at the end if you guys have questions, but that's something that everyone is shopping around right now. Other platforms are requiring or having to purchase, CookieBot or something like that, a consent notice, where Joomla has plugins and extensions that are available and have been vetted. So again, yay Joomla. So when you're looking at your organization, it's a 4-step process for creating a privacy framework. And I'm sorry, again, assess, protect, sustain, respond. And we're going to go into those a little bit deeper. So what that really means. Oh, that's interesting. Wasn't like that a while ago. Anyway, so when you're assessing, and this is what I was talking about a bit earlier as far as the marketing and the ad scripts and the Google Analytics, you need to sit down and look at what you're collecting and why. So for me, as an attorney, I don't need people's phone numbers. Attorneys are not able to direct contact or solicit businesses, so there's no reason for my website to collect a phone number because I'm not going to call you. If you want to talk to me, call me or email me. So similarly, I don't need your address. I'm not going to send you a letter. So limit the information that you're collecting. First of all, what are you collecting? Why? How are you doing it? And are you gathering consent? Do you have questions about this slide for when we're assessing the data from a very basic level before we get into anything? Okay, cool. I'm so sorry that these are messed up. I converted it, but protect. So my favorite part of the protection planning is the contracts. I know you guys are shocked, but different aspects of contracts that come into play with GDPR and with privacy. We've talked about privacy policies. With CalAPA, the law was in 2003. 16 years ago, the requirements for tech were slightly different than they are today. So they have bare minimum requirements for the California privacy, which is the leading privacy policy litigation in the land right now. And it's basically, you post an effective date on your privacy policy. You state whether you do or do not recognize do not track signals. It doesn't require that you do. It just requires that you state whether you do or you don't. And outlining that you will notify users of a breach doesn't require any specific method, type, timeline, or anything. Just we will notify you in the event of a breach and how you handle data. GDPR, as we've already stated, has a lot more requirements, even in how it's constructed. It cannot be our favorite American legalese where no one can understand it. It needs to be readable. And much like we were talking about CCPA, if children are using your website, GDPR requires that the users be able to understand it. So if it's a children's website, it should be so easy that a child can understand, which I'm still waiting to see, this is for what it's worth, the privacy policy that conforms with all of GDPR law, that is so easy a child can understand it, because I want that. Privacy policies, cookie policies. Something interesting to note. For US-based businesses, you can have your cookie policy integrated into your privacy policy. But the e-privacy directive, or what is considered the EU cookie law currently, requires that it's a separate policy altogether. So if you are advertising to people that are located in the European Economic Area, again, I didn't say citizens or residents, I said people located in the EU and EEA, then you need a separate cookie policy. Data protection agreements. Make sure you have them, and make sure that companies that you work with have them. Like I said, you're responsible now under the GDPR for the compliance, regardless of whether it's the hosting company, the plugins, or whatnot. So their privacy notices now become very important to you. Another interesting aspect of this is certain online platforms require GDPR compliance to be able to use them now. eBay and Amazon, certain seller programs require that you have compliant privacy policies and conform, and they have data protection agreements. So just make sure that you have those in place. If you're a digital agency, web developer, and you have a hosting company, make sure that you have them in place. Now, I also want to say, I'll be very honest with you. Even as an attorney, I expected large companies to understand privacy law and their requirements, have the legal team and resources to draft responsible data protection agreements. That wasn't true. So I recently reviewed for a client a vendor agreement, which was interesting, first of all, because it wasn't a service-based agreement, which is what she was providing. Most of the contract that they provided doesn't even pertain to the deal that they are negotiating, and they don't have other contracts. And again, this is a very large hosting company. But the annex or the attached exhibit was their version of a data protection agreement, and the clause in it said, the vendor, guarantees and warrants that information won't be transferred outside of the EU. What's fascinating about that is it's a US-based company with a US-based vendor, and the information will mostly originate outside the EU, let alone, you know, you can't possibly sign that. So when I'm saying make sure you have data protection agreements with large hosting companies and things that you might be held liable for, please read them. You know, hire an attorney to read them, not a super expensive one because we're small businesses here. But just make sure you know what you're signing and make sure it at least applies to you. Same thing with third-party agreements. I mean, it's basically the same concept. And privacy policies, which we've covered ad nauseum. Please read. I just want to make sure if there's anything here that we want to cover now. Like I said, I'll have the slides available, so I don't want to stress you guys. It's almost after party time. Again, you know, part of the protection is contracts. We've talked about privacy policy, terms of use, or another one, terms of service. Make sure you have those on your website so people know what the rules that they're bound by are. Client contracts. There was something specific I wanted to tell you guys about this. Oh yeah. So yeah, there's a lot. So don't worry about everything that's up there. So take pictures if you want to, but I will actually reformat this because there's something about warranties that I want to change and update. Warranties in the U.S. it's UCC. Commercial code, warranties of merchantability fit for a particular purpose. They have to be in all caps. The font needs to be set aside and larger than everything else because you're telling your client, yes, I'm selling you a website, but I'm selling you a website and I'm not guaranteed it's fit for any particular purpose, that it's going to function at all times, that it might not cause injury or death, which is something fun that lawyers throw in, the idea that a website would actually kill someone. But you know, the warranties are something that is huge. I have an entire talk just on contracts, so I don't want to up with here because I know we're running short on time. But the acceptance clause is another major one. If I know none of you would have clients that don't get back to you in a timely fashion, right? Yeah. So make sure that you have something in your contract that if they don't, there's an approval or acceptance period that if they don't get back to you after 3 to 5 business days, whatever you deem is appropriate, that it's deemed approved and you can move on. Anything outside that approval period, either they would need to execute a change order and or shelve the project. And charge them to bring it back in, because in the sales negotiation standpoint is I've given you this quote based on my ability to allocate resources for this amount of time. This isn't an open-ended project for a year of my life. If you want to shelve it for 3 years, or 3 months or 9 months because you're having a baby, great, but we're going to suspend the contract and we're going to renegotiate the price when we come back to it later. So make sure you have that in writing. I think that was, wait, hold on one second. Give me 1 second. Make sure you don't do something stupid like a clause in your contract that says this website will conform to all applicable laws, municipalities, and ordinances. I kid you not, I have somebody who has been in this industry for 20 years. He's actually lessons on contract negotiation, not an attorney, that has this in his master service agreement, and he told me he paid an attorney $10,000 to draft this agreement. I was like, what? This is law school 101. Don't certify and become the insurer for someone else's legal liability. If you want to say something like let's say it's accessibility. Obviously, first of all, we won't get into accessibility right now, but lawyers don't know what's legally required for accessibility right now. The law does not state actual requirements. The closest thing that we have is the WCAG guidelines. So if you have a client, you want to negotiate this in there, say we will, your website will conform to best industry standards or to industry standards and WCAG 2.0, whatever the version is that exists and that you're doing it, be specific about what you're conforming to and or say industry standards. But please do not put something in your contract that says that the website will conform with applicable laws. Again, I just told you that US and big world out there and every law in the world, no. Okay, so sorry. Again, I couldn't believe that happened, and that's why I want to make sure you guys know. Don't do that. Don't give them privacy policies. This is something that I've had a couple, it's typically the smaller digital agencies that are trying to do a value-added service for their clients where they give them a privacy policy. First of all, again, I told you Joomla is ahead of the curve with the privacy suite. You guys have a basic template included in the back end, but there are free privacy policy generators. Direct your clients or users to get their own because you don't want well, they gave me a privacy policy and, I got sued or blah, blah, blah. Just direct them somewhere else so you're not responsible. Yes, sir.
Any idea how to fix that now that we've done it maybe 150 times?
I always
Fix what?
tell them to go to a
Giving them the
generator
privacy
and
policy, so.
Hold on one second. I'm so yours?
The question is how to fix it now that became a standard part of our development task to add a privacy policy page for clients, and so we've done
It's the same. Okay,
maybe
so
150 times now.
certainly. Give me 1 second. I want to put my hair up. It's driving me nuts. Yeah, it's the same as stock photography, right? Some agencies provide stock photography, and other agencies require that the client provide the stock photography. So all you have to do is, yes, I'll integrate a privacy policy. Where is it? Make it one of their deliverables that they provide you with.
I'm talking about though fixing the damage I've already done.
Mitigating your risk. That's a contractual issue because I would want to see what you have in your contract regarding the responsibility of you to provide them with a privacy policy.
No,
You don't have one, right? So you gave them one, but the law, what, 5 years ago, 3 years ago, they have an ongoing responsibility to comply with the law. You're not their lawyer and you're not their legal department, which is what I would say to them if they contacted me. Hey, okay, yes, I did give you a starter privacy policy, 10 years ago, but a lot's changed. They might be in different states. There's a lot going on. So there's arguments, and again, this is if we're litigating.
Right.
You have defensive arguments, but just as a practice, don't do it. Don't open up that can of worms. And anyone can sue you at any time for any reason, myself included. So none of these are surefire ways. Some of the way to surefire is the contractual aspect. Lock it down. Lock the language down. I am not responsible. You're solely responsible for compliance with laws. Da, 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 da. But yeah, I mean that's the safest thing that you can do is just limit your liability and not do that.
I have a question. I have several clients that are in Europe, and one of the questions I have is their websites are GDPR compliant. It was a nightmare to get them that way. My website, however, is not because I don't have time and it's a nightmare to do it. And I don't want to spend my time dealing with that on my website. Some of them do have accounts on my website. With them being in the EU and me being in the States, am I obligated to meet the EU law on my website with them? Can they sue me using EU law,
Yeah.
DPIA law?
Yes.
Can they sue me being a U.S. business?
Yes. So that's why we're talking about it today. Sure that you have information and
That's
know.
what I thought based on what you were saying.
Yeah.
I wasn't sure.
No, absolutely. So the legal jargon is extraterritorial. Well, and Germany, when I talk about California, Germany is the California of the EU. They are the most stringent. So yeah, you have data protection agreements in place, and provision that you're going to specifically need to look at and address. Everybody needs to have this provision, but you more than anyone, if you know that you're actively working with them, is the cross-border transfer provision. Yeah. So it's the how you treat information. First of all, U.S.-based business information may be transferred outside of your
My server is in Germany to avoid all of this bullshit. Excuse me.
No, but it's not avoiding all of this BS because it's located in Germany, but you're located here. How does the information get from here to there? Cross-border, right? So you make sure that you're addressing that. And now there's something called the EU-US Privacy Shield. There's different ways to comply with the standards. I know this is a lot. But there's binding corporate rules and regulations where you write them into your that's typically used by very large corporations. There's EU-US Privacy Shield where you can voluntarily apply to this. It's basically like a reciprocity agreement that the US has with the EU that you apply to it as a US business, the policy to make sure you're in conformity and you're actually treating privacy the right way. Last one, this is small business's favorite one, is standard contractual clauses. So there are a group of clauses that are approved by the European Commission and information DPIAs that we can incorporate into. So this is, you're going to want to write down if you can. The
I wrote that one.
Yep, cross-border transfer, and look at the standard contractual clauses. Yeah, I mean, it seems like such a, no, I know, it seems like a stupid basic thing that I'm saying, but when you Google GDPR, cross-border transfer, and standard contractual clauses, it'll pull it right up, and you'll get to read all about, what that means and what the impact is and why you need to know it. Also, if you're dealing with a privacy attorney, they will also know, and they'll draft it for you. So the protecting yourself have an internal privacy policy. In the EU, they tend to differentiate between privacy notice and privacy policy. Their privacy notice is what's on the website because you're merely notifying people of how you treat or the privacy policy is your internal corporate policy about how you're going to handle data. And that is every aspect of data. So that is the actual collection. That's the physical access to the data by your employees. Whether you bring your own device, where this is a big one right now from a security risk standpoint, where large banks will have an app where their employees can log into a work terminal or something through the app, and they're using it at Starbucks in an unsecure situation. So there's, it's a lot. So internal privacy policy. How many people here have employees? Okay, so you're going to want to incorporate this into your employee handbook. If you don't, perfect. Okay, and incorporate it in there because again, we're talking about reducing your liability. If you
don't have a dedicated email for privacy-related requests, that's interesting.
And get to that in the final section, and I want to blow through these, but I want to cover what you guys want to cover. So if I'm going too fast on things that you need more information, let me know. Again, this is all kind of consent we covered, and make sure that you're looking everywhere. Just by a quick anecdote, work on privacy audits at an enterprise level. One of the things that privacy professionals are selling right now is privacy audits. And a lot of that is go online, fill out a questionnaire, and I'll create your privacy policy. That information that I'm using to serve as a foundation for the privacy policy is only as good as the information as the person that gives it to me. Do you actually understand my question? Absolutely not. I don't even understand the question that I'm asking when it's highly technical. Like, I've looked at these questionnaires, I'm like, I don't know. So, and it's very similar, like they're asking and where information and data is stored. So this is an area for you guys to build your businesses, or a service for you to partner with a privacy professional or someone to offer this. Because privacy by design is now a legal requirement for GDPR. we have to integrate privacy and security. They have to conform with those standards. So having a privacy audit as part of your discovery process is a very good business decision. Questions? Moving on. And I just said, security is baked into laws. This is base 0. I don't think I'm saying anything here that you guys don't. Development 101, two-factor authentication, secure passwords, CAPTCHA, appropriate permissions. So don't need it. So again, we've, yep, back button. Yep. Build, test, repeat. Anything, verify your sources, make sure the plugins, third-party integrations, vendors, and everything that you use are trusted. Make sure that you're reviewing their privacy policies. Don't take their word for it. Review their code. You are responsible for privacy. So this is, again, this is the part of the protection is actually assessing, do you need the information, legal basis for all information that you collect in the EU? So make sure that you're only collecting what you need. Again, we already gave the examples for I don't need somebody's address as an attorney, so I don't collect it. Why would I? Wow, those are duplicated. You guys can take the slides. I'm able to talk real fast.
Red Bull.
I know. I was like, love that energy drink. Yeah. Okay, so anonymization, pseudonymization. Goodness gracious. Things you're going to want to look at. Google Analytics changed a lot over the past year, so just make sure that you're continuing to design with privacy in mind. Yep. So again, we're talking about making it a clear opt-in rather than opt-out for no more automatic collect. Don't need that. Okay, so documentation I already told you. Joomla Privacy Suite has you covered for a lot of it, but just make sure, as I said, we're creating the privacy framework. If you have those policies, incorporate them into your employee handbook. Make sure that you're audit, that you have an impact assessment that's on file. God forbid anybody ever ask you questions, you can show a report was done on a quarterly basis, annual basis. You need to be able to show them what you've done, why you've done it, and what your justifiable legal basis is. So make sure you're documenting everything. And stating again, I said previously, this isn't something that you attain, it's something you maintain. Privacy is an ongoing process as the law evolves, and you have a responsibility to keep auditing, monitoring. You know, are things continuing to function well? Can you do better? Can you be more secure? You need to make sure that they understand what's going on, because you're unfortunately responsible for their actions or inactions when it comes to privacy and data breach. Make sure that they are empowered to not only do the right thing, but to notify the right people in a very quick amount of time. So, information requests legally required by the GDPR. This is something that, again, for other platforms is overwhelming, but for Joomla it's been integrated. So you have, under GDPR, now 30 days to respond to a data request. Fun. So people have been writing Facebook and saying a copy of all of the information you've collected on me, and voluminous amounts of, now as small business owners, the amount of information that we collect, again, now that we're incorporating privacy by design, is very limited. So it's not as overwhelming and daunting of a process, but make sure that you have the ability to respond in a timely manner, which is why you may want to get a specific email. You don't want these to get lost in translation. You don't want to have to explain to a DPIA why it took you 90 days because it got sent to the spam folder. Did you have a question? Yes.
Yeah. So I'm just starting to get to with a couple of clients that are doing international business in one way or another in Europe. So that's because I have 2 clients. One of them is all over this.
Congratulations.
Got to get it all squared away, and let's hire lawyers and let's get off. The other one is like, well, what are they going to do? I don't really, they're pushing it off. Don't really have a whole lot of interest because they don't really understand yet. So, and I can see this happening with other clients too, where if it ain't right, what are they going to do? France is going to come and sue me, you know what I mean? So those are my 2 questions, is basically what could in fact happen with an American-based company that isn't really focused necessarily in Europe, but somehow somebody in Europe is businesses with the website.
So this is part of what we're going to be learning trial by fire and on a case-by-case basis as this gets litigated and enforced. We can speculate, but we don't necessarily know. We know that the EU has the ability to fine and police U.S. businesses. Yeah, it's 4% of the gross annual from the year prior as the most harsh and stringent requirement, but it's also a sliding scale, and there's a process. I will link in the slides when I do my post on my website to the very amazing basic kind of overview of GDPR, like the fine and things like that. But I'm sorry, the last part of the question, U.S.-based businesses, what are they going to do? Yeah, we don't necessarily know. Yeah, we're gonna see how that plays out. And what was the other question you had?
That's essentially is how to convey that sort of idea to clients that this isn't something that are accustomed to. Obviously, it's a normal concern that usually concerns you something that's outside of the country so much. But now,
yeah, I mean, so one of the you are all more practicing functionality than I am. I understand jurisdiction, the law, and what they are able to impose and what would constitute an injunction in the U.S. You would understand the technical implementation of how, but one of the penalties is blocking the site from use or so that is what they're talking about. So you can lose the ability to sell or do business in the EU if you don't conform to the law.
So it wouldn't be in just one country; it would be all of the EU.
Yeah, 31 countries. It's kind of a large market to lose out on because you failed to comply. And what was your question? Oh, sorry. You haven't asked me any questions. Let me get to you first.
So, similar to his, like if I have a client who's like, we don't care about DPR, should I put in my master service agreement with them basically saying like, I explicitly saying that, you know, if y'all fail to meet and we don't design it, you know, we're going to try to do some privacy design stuff, of course, but you see what I'm saying? Like,
yeah.
I don't want it to come back on me because I failed to go against.
Right. So I would do twofold. In your master service agreement, I would have a clause stating that the client is solely responsible for compliance with all applicable laws.
Okay.
Right.
All right. And that would
so
cover
that's on them.
accessibility too, I guess, as well. If
Yeah. Oh yeah.
Something.
So privacy consulting as a service.
Yeah.
Why would you be legally responsible, especially if they have attorneys? It's their job to know what it is, and you know. You work as a liaison project management working with their team. Let them assess, like maybe they need GDPR plus Italy versus Romania, you know, so let them tell you this is making you better salespeople. It's better at your business, limiting your own liability, but being able to have a basic knowledge and understanding to talk to your clients. So yeah, did you also have a client or a question?
So I started out thinking that maybe we would just try it for all clients. But I'm thinking now, really, after hearing all this, maybe we just have in our contract that we don't address privacy at all, except
unless you have somebody on staff that is able to do a privacy audit, that's able to ask the questions and assist them with assessing the legal basis for all of them. I would steer clear of it from a liability standpoint. Accessibility, you know, works with and kind of is a concierge and facilitates services, and she was thinking about offering an accessibility service, and I was like, what? Do you even know, you know, what's required with that? But there's vendors out there that do it. That there are people that will accept the liability and will issue you a letter of accessibility and things like that have, you know, 135 people in a remote portal that will go in and test for every type of disability. Are you a small shop with 3 people? You know, not that you have 3 people, but, you know, are you going to be able to provide that level of service and insulate? No. I'm going to okay, data breach. Great and amazing privacy professionals will tell you it's not a matter of if you have a data breach, it's a matter of when, because we all do. Attorneys have a higher level of standard for confidentiality and whether it's an employee that goes rogue, takes information with them on the way out, or it's some kind of leak. It's something that we need to be prepared for. So I want to give you a framework. This is the framework for what would happen, oh my God, if I had a data breach. So first you're going to, again, privacy is a state issue in the US, so there are 50 different privacy laws. So you want to look to how do they define breach and what is the event that gives rise to the breach. Again, I differentiated between whether it's a physical client, vendor, employee, somebody that steals data versus a tech, whether it's a third-party vendor. Did I hire a security company to provide a service and they failed? So one look at the information covered in the breach. I'm hurrying. Okay, so first look at the information covered in the breach because you're going to look at the federal laws first, the ones that I talked to you about and that you have the slide. Is it HIPAA laws? Then what was the harm? So is there actual threat? Did somebody steal bank accounts? Was it their phone number that was leaked? Safe harbors. Are there any defenses or exemptions? This is a systematic checklist for your business. If I have a breach, this is the legal analysis that you would do. Statutes require notification to the consumers without exception. If it's a breach as defined by that state, if the event that gives rise to it necessitates it. But over half of the 50 states also require that you notify an additional agency or authoritative entity. That might be the state attorney. And there's also different timelines, which is what you need to be. The type of information, whether it's financial information or you're a financial in the financial sector, is a factor. In the state of South Carolina, you have to notify an insurance commissioner. So again, first you look at federal type of information, then you look at the state where the clients whose information you want to start prioritizing. The same way you pay off credit cards and you pay off the ones with the highest interest rates first, you want to get notifying the people with the shortest amount of timeline first. Make sure that you're notifying the right people. And again, you have this compare and contrast. 72 hours here, 60 days here. There's no rhyme or reason to this. Basically the database of the 50 states and where you could find the resources for the timelines associated with data breaches. This is your privacy operational life cycle, what you learned, everything that I've shared with you in an hour, jam-packed information. We've asked questions as we've went, so unfortunately there's no Q&A period. Yeah, sorry. I only had at the Kinney firm up there. That's it's right here. It's basically that.
Where are the slides going?
KinneyFirm.com. KINNEY firm.com. Yeah, Rian at KinneyFirm.com.
Just your first name, right?
Yep, Ryan. But my email address is Rian at KinneyFirm. There's no the.
Oh, getting even more confused.
Yeah, I know.